All right. So here's what we're going to do. We're going to talk about our next speaker. And if you know us, if you know Alison, which most of you do, when it comes to attorneys, we love them. But we love Evan the most. Okay? Evan is our go-to guy in the law world. Everything from trademarks to copyright to business setup to how do we do this? How do we handle this situation?
To people stealing,
to people
trademarks.
Swiping our stuff. It's just crazy. And Evan, so we had somebody coming on trying to like hijack some affiliate credit type stuff, which was, and Evan wrote this letter. I was like, yeah, that was amazing. It kind of terrified me. So he does everything law.
Wow, thank you for that intro. I don't want to spend time on going over my journey over the past 10 plus years from your typical lawyer to where I am today, e-com seller, entrepreneur, this lawyer. I'm just a much better person. I share a lot on social media. I don't want to waste time with that now. I want to jump right in. So I got a call about 6 months ago, and I remember it was a Friday night. Pizza night with my family. I just finished working, about to sit down and eat some pizza, and I got the call and I just ignored it, figuring, I'm going to sit down and eat some dinner, and it's important to leave a message. No message. I figured, no big deal. Same person calls again, no message. Figured it was spam or some robocall. They call again and again and again. 5 times I finally pick up. I said, hello, how may I help you? Is this Evan Sauer? I said, yes, who is this? My name is Judy. And it sounded like she was hysterically crying beforehand, so it was kind of hard to hear, but she said, hi, I'm Judy. I think I need your help. I think I screwed up. I don't know what to do. I said, all right, well, tell me what happened. So I just got home from work and I sat down, I opened up my email, and the first email that popped up was this 2-page email from this nasty lawyer who said, stop selling my products. I don't have the rights to my brand. Pay my client $300,000 now or we're going to sue you. And I've seen plenty of these emails to know that half of them are nonsense. So I said, all right, is it true? And she said, I don't know. Okay, all right, well, do you have the rights to use your brand name? Is somebody else the owner of that brand? I'm not really sure. Well, when you started, did you search and find that out? Did you, look on Google, anything like that? And she said, no, I just wanted to jump right in and start selling. I was excited. I didn't know any better. I said, all right, not a big deal. What's the name of your LLC? And is it active? When did you set it up? I didn't set one up. The same thing. I wanted to jump right in. I figured I would do it later. I said, all right, Judy, take a deep breath. I know what we need to do. Can we talk tomorrow? I need to finish my pizza and think about it a little bit, but I know what we need to do. Can we talk tomorrow? And she said, yes, no problem. And we hung up the phone. Unfortunately, Judy's not alone in this case. 53% of small businesses are involved in some type of dispute or some type of lawsuit. That is crazy. Over half of the people watching this right now will be in some type of lawsuit or dispute. The crazier stat to me is that those businesses will spend anywhere from $10,000 to $150,000 fighting that. That is crazy. Think about that. Could your business survive that? I don't think mine could survive that. If you had to pay that out in not only lawyer fees, but judgments, this and that, I couldn't survive that. But I promise you, well, I can't promise you I'm a lawyer. I really, 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 really believe that if you stay with me for the next 20 minutes or so, that this will be motivational, that I'll show you how to avoid being in Judy's position, how to protect all of your stuff, right? And actually make more money while doing it. Is that cool? Does that sound good, guys? All right, awesome. So how are we gonna do that? Number one, by protecting your business. Number two, by protecting your brand. And number three, by protecting your family. Now, also, as I'm going through this, I want you to really think about and remember why you started. So you see the sign behind me, I don't know, this way. Remember why you started, right? Some people it's because they're financial freedom. Some people it is just for yourself, some your family, some just wanted more money. Whatever it is, remember why you started. So let me share some slides with you and get this thing rolling. All right, how's that look? Am I good? Give me a thumbs up. Can you guys see it? Awesome. All right, so number one, jump over here, protecting your business. This is all about entity choices and written agreements. Now, what we're going to learn here with entities is why you need one, right? How to choose the correct legal entity to use, and when and where to set up your entity. Now, why do these things matter? Right? This is the foundation of your business. This is the first thing that you need to do before you start. This is why Alison has it as the first step in the course, right? Get your LLC, get your entity going, right? I get two big pushbacks. A lot of people say, look, I don't have the funds to do it. I need to source products. I need to buy products. I got to get going. I get it. It costs a few $100s to set this thing up, but it is vital to do it, as we saw Judy. In Judy's situation, she didn't do it. So get it done right away. The other thing I get is, look, I'm a small business, right? Do I really need this and the other legal stuff? Well, Apple and Amazon, all these big companies didn't start out as small businesses, right? They needed to set these entities up correctly in the beginning as their foundation to grow where they're growing today. All right, so let's jump into the why. So liability protection, we've all heard this, right? This is one of the biggest, most important reasons why we need a legal entity like an LLC, which is spoiler alert, what I recommend, what Alison recommends. Most people hear this, but I want you to understand really what it means. I'm going to walk you through the scenario. So if I don't have an LLC, if I'm just myself and I'm a sole proprietor and I'm Judy, right? Same thing. And I get sued and go to court and I lose the lawsuit, and the court or the judge says, okay, Judy, you owe this other party $300,000 because you were using your brand, or you breached this agreement, right? You didn't pay your supplier, or you weren't able to pay your lender back, whatever it would be, or your customer got injured, you owe this amount. Well, Judy's not gonna be able to pay give a check for $300,000 to the other party, right? So how is the other party gonna actually collect that money? Well, Judy individually left open her personal assets. So that other party is gonna actually put a lien on on Judy's house, just like you have a mortgage on your house, right? They can collect from that. And by the way, that could be a default under your mortgage, which is even worse. They're gonna take money out of your personal bank account, which you're gonna be allowed to do. They're gonna put a lien on Judy's car, and they're actually gonna garnish her wages. So every week she's gonna get wages, and that other party is gonna get a percentage out of her wages until that $300,000 is paid back. I mean, it's nuts. Judy could never live like that, right? She would have to file personal bankruptcy. Now flip the script, right? If Judy owned an LLC, right, and the LLC was sued by this other party, and the LLC had to pay the $300,000 back, well, the only thing that other party could collect is what the LLC owns. The only thing that the LLC owns, right, the majority of the time are the assets, which are the inventory that you guys have, and whatever money is in your business bank account, which is usually $0 because you're going to pay yourself and everything else. That's it. They can't touch what Judy has personally. That's the beauty, and that's the scenario that we need to look at when we think about liability protection. That's why these things are so important. The next reason why we need to set these up are financial benefits. Who doesn't love those as entrepreneurs, right? We all hear the tax benefits and the write-offs, which are true. I'm not an accountant. You can talk to your accountant about that. But here's the other cool financial benefit. When you go to negotiate and order products from suppliers, right? Normally, the more you order, then the better terms you'll have. It'll be cheaper, things like that. Well, we're afraid to do that because what if we can't pay them back, right? Do I have the money to do that? You know, what if I don't sell enough? What if they come sue me and come collect that money? Well, if I have an LLC, right, knowing that I am protected, knowing that my personal personal assets are protected, I have that comfort level to say, look, I'll order 1,000 units. If for some reason, and it's not going to happen, especially after this conference, we all know that we're going to succeed. But if for some reason I can't pay that back and they come after me, I'm okay, right? My business will shut down. I'll start a new business, but that's okay. They only can take what my business has. To me, that's really cool and comforting. It also makes you look like a real business, right? You, to your customers, to your suppliers, to your vendors, hi, I'm the owner of my LLC. I'd like to do business with you instead of I'm just, an individual, which is okay. Here's my business. So now we know the why. How do we choose the right entity? We've all heard sole proprietor. That's just me or Judy doing business as herself or ourselves, right? You don't have to file anything. There's no requirements to file anything except you get your EIN for Shopify and things like that. It doesn't cost any money up front to do that, which is nice, but you don't have that limited liability protection like you do as we just talked about. Partnership is similar to sole proprietor, except if you have more than one party, more than one person, the default is that if they don't set any entity up, they're considered a partnership and they're liable each to the partnership themselves. Similar to if I was a sole proprietor, they could each get personally sued and things like that. You don't have any liability protection. There are also no filing requirements with the state, but again, you don't have that liability protection. The third, which is the one that I recommend, the most flexible, is your limited liability company, your LLC. You file your articles of organization, your certificate of formation with the state, sets it up, other filings. You have your liability protection, which is beautiful. You can have as many members as you want, owners, which is also nice. This is my go-to. It's very flexible. There are not many formalities like if we set up a corporation. Now, a corporation is the last entity, well, there's other entities, but the last major entity that you could use and set up. It's similar to an LLC. You have your liability protection, but there are more formalities. You have to have annual minutes, you have shareholders, you have to have bylaws, this and that. There's not as much flexibility. Also, the default is that you're taxed as a C Corp. It's called double taxation. So I don't want to get too much into this, but you're taxed at the corporate level. So any income or profits that your company makes, the corporation has to pay the corporate tax, and then anything distributed to or paid to the shareholders, which is yourself, you pay your normal income tax. And then the S Corp is the election with the IRS, which that doesn't happen. And you could also have an S Corp election with your LLC too. I don't want to get too much into the accounting, but those are the choices. I recommend LLC. So I love this saying, you are the owner of your business. You are not your business. It's also so cool to say, right? You're the CEO, you're the manager. This is not a hobby. This is your business. Treat it like that, right? And go out to the world and say, look, I'm the managing member of my LLC. That's how I do business. And then legally you'd be okay. So when and where, I get this a lot, when and where do we set up our entity or LLC, right? When is easy for me. And I said this before, it's the first thing that you do. I'll have no other response. That is it, the first thing you do, or as soon as you can do it thereafter. The where is, I get a lot of pushback a lot of times too about people that live in California. It costs a lot of money, $800, but can we file in Wyoming or Nevada? Sure. But the thing is, you're always going to have to file, and it's law, you're always going to file your LLC where you do business. And where we do business is where we live. We're doing it out of our home office. So if we're doing any writing off or paying our taxes out of, say, California or wherever, that's where you need to file. And it makes it a lot easier. So this is a cool design that I've come up with, graphic. I don't know, there's a lot of people have seen this already. I don't really have a name for it. I think I'm calling it Bubble Protect or Legal Protection Bubble, whatever it is. If you guys have a cool name, let me know. But the idea is we're starting to build this layer of protection around ourselves, right? And you can see the LLC, that's the first layer of protection. Now we're going to get into written agreements. We're still into protecting your business. This is just another part. So what are we going to learn with this? Why do you need written agreements instead of oral agreements? When do you need to use the written agreements? And then what types of written agreements do we need to use? So why do we need them? Again, we're coming back to this liability protection, which is, you'll see it throughout the presentation, it's key. If I have just an oral agreement, right? Normally that's going to be like, hey, Judy, you're going to pay me this for these services, right? And that's it. It's not going to have like a term. It's not going to limit damages. If something happens, you're able to do that in contracts. You can cap your damages. It's not going to have a non-compete or a non-disclosure agreement in there, which somebody could just take your ideas. Look, we sell products. We don't want anybody stealing our ideas. And then one example I have up here this is huge now in the pandemic, is the force majeure clause. And I've used this repeatedly over the past, 4 months now, I guess. It's going on for so long. With my clients, if you have a big event or you need to get out of a contract because you can't perform because, say, COVID is going on or any other catastrophe, it could be an earthquake, it could be whatever. If you don't have this force majeure clause, then you're still liable to pay and perform the services under that contract. You're not going to talk about that orally. You need to have that in writing. It also puts the parties on the same page. Now you actually create an agreement, right? It's in writing, it's on paper. There's not that memory loss. I don't remember what we said, this and that. So it starts the relationship off professionally and well, and also weeds relationships out that you don't want from the beginning. If somebody says, I really don't want to, enter into that agreement, well, guess what? Maybe that means that they're not going to honor any agreement that you have to begin with. And then here we go again. This is another category that keeps popping up, the financial benefits, right? Who doesn't love these? Besides offer level, which I talked about before, in negotiating, you're going to have this professional looking written agreement. You're going to say, hey, supplier, hey, vendor, here's my agreement, take a look at it. And they're going to take you seriously, right? You're going to have more leverage and negotiate favorable terms than if you just went to them and said on the phone, hey, can I get these products and this and that? So when do we need to use these? Simple answer is always. Some cases, this is called statute of frauds, state by state. Some cases, you actually have to have written agreements to be enforceable. Things like wills and real estate documents. If an agreement is longer than a year, you need to have them. Also, privacy policy, guys. So we have our terms of services. Hopefully, we all have privacy policies on our website. If we're collecting information, people's information, we need to have those written out on our website or wherever somebody can access them. And then obviously the larger vendors like Amazon, they're going to have their terms of services and things like that. You're never going to be able to negotiate with them, but you can opt out, right? You don't, if those terms aren't favorable to you, then at least take a look at them. So what types of agreements are we going to have, right? These are your business relationships. You have some type of relationship with the government. You're paying the money, taxes, right? Employees you might have, or independent contractors. Intellectual property, you're licensing some intellectual property, you might have your own, your customers, your competitors, your suppliers, vendors, real estate. Anytime you're paying money for services, or vice versa, you're providing services for money, you need a written agreement. So here we go again. Now we're building this bubble. We're continuing to build the bubble, right? So we have the LLC as your first layer of protection. Now we have the written agreements. So we're out of protecting your business. Let's move on to protecting your brand, the who, the what, why. This is all about trademarks, guys. So what are we going to learn? Who needs to worry about trademarks? What a trademark is? Why trademarks matter to e-com sellers? And then how do you choose the right brand name or trademark? So who needs to worry about these things? The simple answer is everyone. And I'll explain to you in a second. Your brand, which is really your trademark, is the biggest asset that your business can have. Now, what is it? What is a trademark, right? It's defined as any word, slogan, symbol, design, or combination that identifies the source of your goods and services and distinguishes them from the goods and services of another party. Well, what the heck does that really mean? It's really just your brand, right? It's your brand for your goods and your services. It could be your logo, those things. How you identify and sell your goods. What logo do you put on there? What brand name do you use for that, right? An example, obviously, is Because I Can. Nike, we all know Nike. G2G, these bars, right? The G2G, that's their brand name. We get trademark rights here from use. A lot of people ask me this, meaning that the first time you use your brand name, your logo associated with whatever you're selling a product, and this all just means the first time you sell a product online, that's the easiest way to look at it, you automatically get what's called the common law trademark rights. It gives you certain rights as to where you sell, if I only sell in certain states, but you automatically have the trademark to that. And that's when you see that little TM, that means the trademark when it's not registered. I get this a lot too. Business, can you trademark your business name? Well, business name is not necessarily the trademark. Some companies might have the same, like Amazon, that might be their trademark, right? And Nike, same thing. But most of the time, your LLC name is going to be different than your brand. You're going to start your LLC, you're not going to know what you're selling, right? So, and you might switch gears on your brand. So whatever your brand is and whatever it's associated with your products, that's what the trademark is. And then I also get the confusion as to, all right, what's the difference between a trademark, a patent, and a copyright? The trademark is your brand, like we talked about. The patent is the invention or the design of the thing. And the copyright is the content. Let me give you a quick example. Take, for example, a vacuum, like a Shark vacuum, right? Shark is the brand name, that's the trademark. The design and the invention of whatever the vacuum is, they have a million of them, whatever the vacuum is, that's the patent. And then if they did like an infomercial as to, explaining what the vacuum does and showing it, the content of that infomercial is the copyright. So hopefully that makes a little more sense. You can have each for any type of product. Now, why does it really matter to e-com sellers? Well, this is what I said before, and Forbes said this: your brand is the single most important investment that you can make in your business. And it really is. It's literally like the second thing that we do after setting up our LLC. We're coming up with our logo, our branding, things like that. Think about it, right? How much did you guys love these G2G bars, right? And that was just one flavor. I love mine. You're going to look at this and say, well, I'm going to go get another because I love that flavor, right? I love these things. I'm going to try all the other ones. Just like Nike or anything like apparel, that brand, so you're going to buy more. Same thing with your customers. They're going to do the same thing, right? They're going to know your branding. That's why it's so important to protect these things. And again, the same thing. What if you spent thousands and thousands of dollars, like Judy, right? And months creating this brand, social media, whatnot, marketing, and now it just goes under because you find out you can't use it. That's why it's so important to us. Don't let it happen to you. All right, so how do we do it then? How do we properly do it, right? The first step is you choose a strong brand name that can actually be protected. And I'll talk about these more. Make sure nobody else has trademark rights, right? Do the proper search. And then we police and protect your brand name, right? Monitor and don't lose your rights to your trademark. So the first thing is choose a strong brand name. There's a spectrum, and you can kind of see this graphic of what can actually be a trademark. Not every single brand name can be a trademark, and things that are like generic. So let me give you an example. If my brand name's Apple and I'm selling apples, the fruit actually, well, that's generic. That's actually just the definition of it. I could never get a trademark to it. If I could, nobody else could use that for the fruit apple, right? So things that are generic can never be trademarked. You can't prevent anybody else from using it. Same with descriptive marks. So if I'm selling something like, if my brand name is something like a desk drawer, right? And I'm selling a drawer that slides into a desk, well, that's just describing what it is. Anything that describes, any brand that describes what it is or who it is or what it does, that's descriptive, and you can never get a trademark right to that. Now we move on to suggestive. And this is, you're going to have stronger rights and be able to trademark when we start to get to here. These things that suggest what the product might be, things like chicken of the sea for tuna, like you can kind of picture it, but it's not describing it. That would be a strong mark, right? And I believe they probably have that trademark. Then we move on to the best case scenario, which are arbitrary marks. These are the strongest marks. And take, for example, Apple again, right? And this is why you can see how they relate to different products. Apple computers, right? That brand name has nothing to do with computer. Now you know that, but originally it had nothing to do with computers. It was so arbitrary and unique that it was a good qualifier for a trademark, right? And I know it's tough. You want to balance, as a business person, you want to balance this, right? Because you want your brand names to kind of match what you do so people can understand you, they see it and they understand what you sell. But again, think about it. Amazon, Nike, all these arbitrary marks, when they started, nobody knew what they were selling. Look at them now, right? So the first step, you want to pick a strong name. Ideally pick something that's really arbitrary or suggestive. So once we have a strong name, then we do a search, right? So we need to make sure that the name is actually available, that nobody else is using it. And again, the way that we get trademark rights here in the United States is first in time, meaning that whoever uses the mark in commerce, selling it first, has the rights. Now, that doesn't mean that if I sell e-com lawyer, right, is that you can't have the same or similar brand name or mark to somebody else that's selling the same or similar goods, right? So somebody theoretic, I can't say that. Anyway, somebody could have e-commerce lawyer and be doing psychiatry services, right? I don't know. I mean, I guess it's pretty much the same, but if it's different, then that would be okay. They could coexist. So keeping that in mind, what is the process that I take? And I could spend a whole presentation on this, but here's the idea. I start with Google or any other search engine, and I put in quotes my brand name, and I hit enter. If something pops up, I move on to the next brand name because that's a red flag to me. I take it out of the quotes and see if there's anything similar. I do the same thing with domain name searches and the same thing with state secretaries. Every state has a Secretary of State website that you can go search trademarks. And then finally, I go to the USPTO, which is the United States Patent and Trademark Office. That's the main area. That's where we register our trademarks. And I do the same thing. I search for the same or similar marks. Any variations of things, like e-com lawyer, it could be e-com attorney, it could be this or that. And I always get the question, well, how similar is too similar? Well, it's really subjective, and I can't give you a straight answer to that, but that's why we try to keep it as arbitrary as possible. So there's not a chance of anybody having that name. So we have a strong name. We searched and nobody else has the names, right? Which is what Judy failed to do, unfortunately. Now, what's the process? If we register it and take it to another level, what's the process? The first part is we will prepare and we'll file the trademark application with the USPTO. You do that online, you pay the fee. It's not a hard process. Then we monitor it, right? It usually takes about 2 months for them to come back and either say, yes, you're good to go, or no, we need some more information. If you're good to go, then they'll publish it. It's very old school. They'll publish it in their newspaper. They even call it a gazette. It's like the Trademark Gazette for 30 days. And that gives anybody else out there the rights to object to it if they think they have better rights to it. If nobody does that, then within a few weeks after that, you'll get your certificate of registration. You're good to go. You can use that little R next to the brand name, and you've just added a ton of value to your business. And the final thing is there's maintenance requirements every 5 years. You got to file. And you got to police your trademarks as well. So I always get this. Then you said that you get trademark rights once you sell. Why do we even have to register and pay the money, take the time? There are advantages to it. One is you get, and I don't want to get too legal, but one is you get this legal presumption that you're the owner. So remember, the first person to use this mark wins. But if I have the registration, then the law presumes that I am the first person to use it. If another party wants to come and sue me, they're going to actually have to spend the money and time proving that they were the first ones. It's automatic that I have that. So it's a huge deal. You also get to use the mark nationwide. Remember, if you're just, if you don't have a registration, you can only use that brand name and trademark where you sell, what states you sell. And it puts the public on notice that you're the owner of it. So you're going to be able to prevent good guys like all of us who are doing the proper searches. If we see that, we're not going to use it, right? You're never going to prevent the bad guys from coming along and stealing it anyway, but it prevents the good guys. It also, which is really cool right now, is a lot of the social media platforms, especially Instagram, Facebook, if you have a trademark registration, you see that somebody is using that name, you can fill out this little abuse form and they'll take that down pretty quickly, which is really cool for us. Then the last step is don't lose your rights, right? You need to do things like set it off, put the little R, make it bold, give notice that you actually own it, and you have to police these trademarks. It's actually one of the requirements. So you have to go out there and see, spend all day doing it, but you need to make sure that nobody else is using this, and if they are, demand that they stop using it. Awesome. So we got the Bubble Protect back up again, or legal bubble protection. We got our LLC as the initial, the written agreements, the trademark. See, we're building all these layers to protect our business, our brand, our family. All right, let's get into the last piece of this, which is protecting our family, which I think is the most important. This is estate planning 101. And what are we going to learn? Why do you need it to take estate planning seriously to begin with? Why most people don't even have plans? What type of documents do you need? And then once you really worry about planning. So why do you need to take this thing seriously? Well, again, remember why we started. One of my reasons for sure is family and legacy, and I want something to leave to my family, right? If I don't have the proper plan in place and I don't know where things are going, then how am I going to do that, right? proper plan is going to answer things like, what stuff do I have? Where is it going? Where is it located? How is it getting to where it's going? Who's it going to? And then when is it going there? If you don't have a proper plan, and I think most people know what a will is, if you don't have just a basic will in place, the court and the law makes decisions as to where your stuff is going to go. It also prolongs the situation. So the probate court's just a court. It's the name of the court that deals with estate administration, what happens when people pass away. Probate matters that deal with the estates without wills take on average 6 months to 2 years. That's a long time for your family to deal with. It's also the average cost of that, which is probably higher now, is $12.4 thousand, and over 44% of families have conflicts during this time. I do probate. My firm does probate. I see this. It doesn't matter how much money is involved. There's always an issue. We want to minimize that as much as possible. So, and here's kind of the general order. If you don't have a will or anything like that, this is state by state, but most of the time it's going to be, if you have a spouse, your stuff's going to go to the spouse first. If you don't, then your children, then your parents, siblings, grandparents, right? That's just the order. You might not want everybody to have everything or split everything. And then most importantly, if anybody that has children, if you don't have a proper plan in place, at least as far as guardianship, what's going to happen to our children? Are they going to be taken care of, especially if they're minors? That's key, especially for me. I have a soon to be 6-year-old and a 3-year-old. It is vital to do that. And then with a proper plan, also, here's the financial stuff. You can also save money. There's tax advantages to doing that. Again, I'm not going to go into that, but that's one of the key things to keep in mind. So with all those things, why don't people have plans, right? Why? And it's actually really crazy. 60% of Americans don't have wills. Well, here are the reasons, right? Who wants to talk about it? Nobody wants to talk about it. There's also a misconception that it's too expensive. I can tell you that it's not, but that's one of the misconceptions. I don't know where to start. I don't have enough assets. Well, everybody here does have an asset. We have our businesses. That's a major asset. And I'm sure you have other ones as well. I don't have children. That's okay. You might have other people in your lives. If you don't have anybody to give your assets to, what's going to happen is it's going to go to the state. You don't want that. Maybe you want it to go to a charity, right? Which you can write into a will. And, finally, I don't plan to die anytime soon. Well, we never know, right? So get it done. Now, what type of documents do we need? The first is a healthcare power of attorney. This is like a living will. This is, it's like a do not resuscitate. What happens if I'm not able to make my own healthcare decisions? Who does that? What can they do? Those kind of things. Same thing with property power of attorney. It just deals with property instead of my health. The will, most people know what this is. This is your main document. Every estate should have a basic will. Who's the executor? Who's going to be the guardian of my kids? What are they, what kind of things can they do when they can't do? Where's my stuff? What stuff do I have? Where is it going? Who gets my jewelry? Who gets this, and itemized list. It's really specific. So our loved ones don't have to really deal with anything when we're gone. They have this and they can say, all right, this is what they intended, this is what they intended, and so forth. And then we have a trust. I threw this in here. I do trusts all the time, not often. I try to avoid them. I try to make it as simple as possible. To be honest with you, this is a document that lawyers use, in my opinion, to get more legal fees. It's sad, but I think that's true. Some cases, if you're making enough money, it's worthwhile. Or if you want to leave like a family trust, things like that, it's good. But often it's just not necessary. So when do we want to start our plan? Well, like I said before, everything we need to do in this protection is now, right? So start now. And then here's our final bubble protect, right? So LLC, written agreements, trademarks, other intellectual property, and estate planning. See how protected we are now? We're building this bubble. It's reassuring. But Evan, I know you guys are thinking, Evan, I thought you said you're gonna show us how we can actually make money by putting this stuff in place. Well, that's true. So I talked about the other financial benefits, but I really wanted to take a deep dive into this stuff and figure out, besides the legal stuff, right? Why does this matter? Why do we need to do this, right? Why does protecting your business, your brand, and your family, why can it actually make you money? And here's what I came up with. And some of these stats are crazy, right? We have up to 60,000 thoughts per day, right? That seems like a lot, which it is, right? But the more shocking part of that is 80% are negative. That's 48,000 negative thoughts. Think about how long that is for your day. I think it's like an hour out of your day. I mean, it made sense to me because, you know, as humans, we have this protective instinct, right? That we're born with that. We want to protect everybody around us, our children, our family, our businesses, whatever it is. So we're going to worry about these things, of course. And here are some of the negatives that we're thinking about, right? 67% of Americans say that they're concerned about their family's long-term financial well-being. I mean, who isn't? Even if you have money, of course you are. 71% of Americans say that if they had a well thought out proper plan, that they would feel like they're a good spouse or parent. I mean, that's a lot of weight on your shoulders. And then 53% of Americans, right, say that they'd feel more successful if they had a proper plan in place. Those are a lot of worrisome thoughts, right? And that's why it's 48,000 per day. Think about that. You're wasting an hour out of your day worrying. What if you had that hour back? Or a portion of it, 20 minutes of that. How much more could you do with your business and your brand? And how much more could you make money, right? Just by having these protections in place, knowing that your family, your business, and your brand are protected. So let me wrap this up. The big thing for me is keep your bubble strong, right? Your LLC, your written trademarks, you know, those kind of things. Judy didn't have a strong bubble. She didn't actually have a bubble at all. She left herself wide open. She didn't have an LLC. She didn't even know she had rights to her brand name. She left herself wide open, as we saw. So what did happen with Judy? So I did talk to Judy that Saturday morning. Before I talked to her, I did some research and investigation and did find out that the letter, unfortunately, was true. Somebody else had greater rights to that brand. So I recommended that she stop immediately. We talked a while. We immediately set up her new LLC that day. We went over branding and talked about strong brand names. She picked a brand name that day, and she was off and running. We did the search, she was off and running, and she's on another path right now, and she's doing really well. Unfortunately, over the past 6 months, we're still dealing with that other lawyer and that other party who knows that they're right and knows they have leverage and is playing a little hardball. We're in the process we're in negotiations. We're hopefully coming to an end soon. Judy's not going to have to pay that $300,000 or anything close to that. She has paid some money and she's going to pay a couple $1,000s to them, unfortunately, but you know, she's on a better path. So here's the point. Don't be Judy 1.0, be Judy 2.0. Keep your bubble as strong as possible, right? Remember why we started this, right? Family, yourself, whatever it is, financial freedom. Don't let somebody else come along and take that all away from you. Thanks, guys. I really appreciate this.